Welcome back to our class on small claims court at Courtready Academy. Now that you've filed your claim and received a court file number, the next step is to serve the defendant with the plaintiff's claim. Service is a legal term. It means officially delivering a copy of your court documents to the other party. The rules of the small claims court require that this be done properly so the defendant has a fair chance to respond. If you don't serve the documents correctly, your case might be delayed or dismissed, so it's important to get this step right. In this class, we'll cover 1. What service is and why it matters. 2. Acceptable methods of service. 3. Filing proof of service. And 4. What to do if the defendant avoids service. Let's begin. Service ensures that the defendant knows they are being sued, has a chance to read the claim, and can respond to the court within the deadline. The court takes service seriously. You cannot just tell someone verbally or send a casual text. You must follow formal rules about when and how documents are served. For most cases, the plaintiff's claim must be served within 6 months of the date you filed it. The filing date is the date when the court inserted a court file number to your plaintiff's claim. Here is another reason why service is important. The timeline for a defendant to respond to the plaintiff's claim starts on the day service was properly effected. Effected here means completed. For the plaintiff's claim, you or someone you hire must serve it personally or by an alternative to personal service. We will explain what this means. If the defendant is an individual, you may serve the plaintiff claim through the following methods. 1. Personal service. Hand the documents directly to the person. 2. Alternative to personal service. Method A. If you tried to hand the documents directly to the person at their place of residence, but this was unsuccessful, you may serve the plaintiff's claim by first leaving the document with someone who appears to be an adult member in the same household, and second, mail another copy of the plaintiff's claim to the same address that day or the next day. If you serve the individual using this method, the court will treat the service of the plaintiff's claim to be effective on the 5th day after A. You mail the plaintiff's claim, or B. Verify by a courier that the plaintiff's claim was successfully delivered. Three. Alternative to personal service. Method B. You may also serve the plaintiff's claim by sending a copy of it via registered mail or courier to the defendant's place of residence, and have someone in that place of residence verify via signature that this person has received a copy of the plaintiff's claim. If you serve the individual using this method, the court will treat the service of the plaintiff's claim to be effective on the date when the person verifies receipt of the plaintiff's claim through their signature. If the defendant is a business or a corporation, you may serve the plaintiff claim through the following methods. 1. Personal service. Leave a copy of the plaintiff's claim with A. An officer, director, or another person authorized to receive the plaintiff's claim on behalf of that corporation, or B. A person at any place of business of the corporation who appears to be in control or management of the place of business, like a manager. You can serve the documents yourself or ask someone else, like a professional process server, to serve on your behalf. The benefit of hiring a process server is that they are professionals who have done this many times before. That said, there will be an additional cost of hiring process servers. Their prices, in general, range between $100 and $300 per attempt, depending on the circumstances of each case. After service is complete, you or the process server you hired must fill out and file an affidavit of service, Form 8A, with the court. This form requires you to provide a brief description of how you or your process server served the documents. You must also answer the following questions. 1. Who served the documents? 2. How were they served? 3. When and where did the service happen? The person who served the documents must swear or affirm that the information is true and sign the affidavit in front of a commissioner of oaths or court staff. A commissioner of oaths can be a practicing lawyer in Ontario. This proof of service is required for your case to move forward. Without it, the case cannot proceed. The proof of service will also indicate the day when service was properly effected, which triggers the timeline for the defendant to respond. You must be 100% honest in the affidavit of service. We have provided template affidavit of service forms as part of this class. Always remember to use these only for reference, as each circumstance is different. What if someone is deliberately avoiding service, or you have no idea where they live, or you only have their emails and phone numbers? Don't worry. If you have tried everything possible and still cannot properly serve the defendants, the court may, under certain circumstances, permit substituted service. Substituted service means getting the court's permission to serve the plaintiff's claim through a different method other than what is required under the rules of the small claims court. In short, if you can demonstrate to the court that it is impractical to effect prompt service of the plaintiff's claim personally, or by an alternative to personal service, the court may then allow substituted service, such as service via email. To obtain an order allowing you to proceed with substituted service, you would need to bring a motion, a formal request, to the court. Once the court grants your motion, you may proceed with substituted service. To review, 1. You must serve your plaintiff's claim within 6 months. 2. You can serve it yourself or hire a process server to do it. 3. Choose the correct method based on whether the defendant is an individual or a business. 4. File the affidavit of service right after. 5. If service becomes difficult, consider bringing a motion for substituted service. With service complete, the defendant now has a chance to respond. That's what we'll cover in the next class, defending a claim. Thanks for watching. See you in the next video.